Hi, I'm Gregory Dell here with attorney Cesar Gavidia, and today we're going to talk about a situation. It doesn't come up a lot, but we've certainly seen it, and that's when you're working for an employer, you get terminated from your job, and then you want to go ahead and file a long-term disability claim. And the trouble with this is that often the long-term disability group disability policies say that you must be employed at the time you become disabled. So is there a scenario where you can get fired and then subsequently file your disability claim?
Yeah, and Greg, the ultimate issue is basically if that insured or that employee is covered under the disability plans for the employer. And there's an interesting case recently out of the U.S. District Court in Arizona. It's called Eduardo Nieves versus Prudential Insurance Company. We're very familiar with Prudential. We see them all the time. And in this particular case, Mr. Nieves was a satellite communications technician, and he'd suffered from really severe back pain and arm pain following a failed back surgery, which is another thing we see all the time. People who go in, try to cure their issue with, of back pain through a surgery that's been recommended, and then they still continue having back pain. So after his surgery, he went back to work, but continued struggling through the back pain, and as a result of something being completely unrelated to his disability, his employer terminates him because they're reducing their workforce. He then asked the employer if he could apply for disability instead. They denied him that right to apply for disability, saying that he wasn't a covered employee at the time. But he went ahead and ended up applying for disability anyways through Prudential. And of course, Prudential denied him. He goes through all the appeals as he's required to, attempted to get them to overturn their decision on the appeals.
So just to clarify though, he was working full-time up until the time he got fired.
The only difference was that he basically reduced down to a light sedentary job after he went back. So maybe he wasn't going up the scaffoldings or the ladders or doing whatever he needed to do, but he's doing a light sedentary job. But yes, working full-time. He was effectively still covered under the plans throughout the whole time he was working. So they denied him the right to apply for disability. He files all his appeals, exhausts all his administrative remedies, and then ultimately files suit against Prudential to recover his benefits and to be deemed an eligible covered employee under the plans. What's interesting is Prudential tried to throw everything they could at him. They first tried to apply that they had a discretion in interpreting the terms of the plan, and the court in Arizona denied them that because the discretionary language that they were claiming was in the plan or the policy that applied was only found in the summary plan description, and the court said, look, if it's just in the summary plan description, we're following the Supreme Court on this. You basically cannot enforce something on someone that's just found in the summary plan description. It has to be in the plan documents as well. So the court denied them that. And then they also found, basically what Prudential was trying to argue was that at the time he filed, he wasn't a covered employee. In other words, the plan didn't cover him and he could not apply for disability benefits. And what the court found was that Prudential basically arbitrarily selected the date that he was disabled. They said, oh, well, because you worked full-time the day before, your date of disability is going to be the date after you were terminated, and therefore you weren't covered under the plans. And the court said, no, you can't do that. You can't just arbitrarily select a date. And it's basically logically incompatible that someone can be can work full time and also be fully disabled. That's a possibility. Somebody could be struggling through work. They could be, basically there in a physical state, but not there mentally, or not there basically being able to fulfill those substantial material duties of their occupation. So the court sided with the insured in that instance and said, yeah, we're going to find that you were covered under the plan on the date that you were terminated.
So the court basically said, even though you were at work and physically there, we still could make a finding that you were disabled.
Exactly.
Even while you were working.
Right.
And in this particular case, on the application for disability, I'm assuming that the claimant didn't put his date of disability as after the period that he got terminated.
Right. There was nowhere in the record where that appeared that the date of disability was on the date after he was terminated. So he was claiming his date of disability as being basically the date he was terminated.
Right. I think it's a great decision that came out, because if it wasn't this way, then you put the fear in anybody who goes through a surgery or who's suffering through a condition that if they come back and make an attempt to work, and then, God forbid, they get fired like this gentleman did, that they're going to lose all their benefits.
Right.
And if it wasn't this way, then the employer and the disability companies are creating an incentive to make the person stay home and not come back. So it's really not fair. Just on this point, the other thing that we often see is the scenario where someone is working, but gets disabled while they're employed. They don't get terminated. But then 12 weeks or 4 months or 6 months after they stop working, their employer terminates them.
Mm-hmm.
And many people ask us, does that mean my disability coverage ends?
All right.
So does the coverage end because they got terminated? Do they have to stay employed in order to have coverage after they've already claimed disability?
Effectively, if they're no longer working, okay, and their either employment was terminated or they're not working full time, effectively the coverage ends for a new disability. If something came up, 2 weeks later or 3 weeks later or a month later and they weren't covered under the plan, then that coverage wouldn't apply for that disability. But if they'd left work as a result of disability, okay, and they'd submitted a claim and they're going through that claims process, then there is coverage, absolutely.
Okay. And that happens in almost every case we have, is that eventually the claimant's going to get fired from their employer just because they keep them on for 12 weeks for FMLA and then they have to discharge them.
Right.
Now, whether or not that affects health insurance benefits or life insurance benefits or other benefits from the employer, that's a whole different issue that we're not addressing here. But the long-term disability coverage will not end because you've been terminated.
Right.
So this is a very rare fact pattern where somebody gets fired and then files a claim post-disability. It's certainly a possibility, and you shouldn't feel that because you never filed prior to getting fired that you can't. So any issues you have with a long-term disability claim, feel free to call any of our attorneys. We always offer a free consultation, and we welcome the opportunity to help you.